Hello, everybody. It's me again, Janan, here to talk about the legal topic of disclosure, financial disclosure, and child support. Specifically, what I'm going to talk about today is what the general requirements are in terms of the exchange of disclosure in child support proceedings and what happens when the other party doesn't provide that disclosure, which would help the parties calculate child support. So that's what is going to be covered under this video. Just a gentle reminder that this video is going to be providing legal information. It's not legal advice. If you want legal advice, that's no problem. That just means you contact me directly and we have a one-on-one, and then I can give you legal advice based on your specific circumstances and situation. But for today's purposes, it's going to be legal information about the topics that I just outlined. So getting back to that. So whenever you are in the child support realm in court, one of the first things you have to do before a determination of child support can be made is to exchange financial disclosure, financial information. The purpose of that is because child support is based on incomes, and in order for the parties to know what their respective incomes are, they need copies of statements to verify that information. And it's relatively easy to figure out income when you are an employee, as long as you've got the other person's notice of assessment. So you can look at line 150. That's generally at least minimally what you need, and it can help you determine what child support should be. Sometimes when parties are self-employed and their line 150 income is not even necessarily indicative of what they're earning potential is, or the assets, the health of the business, let's say, is, then you might have to provide more than just notices of assessment, let's say, to figure out line 150 income. You would have to also provide business information and statements. Okay, so in order to calculate child support, you need to know incomes, and those things are exchanged. That information is usually exchanged outside of court. It's a very common key step in a child support process. So my practice is always get that out of the way, provide it so we can get on to the bigger issues, which is what should child support be set at? The types of information I'd be looking for as a lawyer include, in order to determine income, include things like notices of assessment, T4s, pay slips, as an example. And additionally, if you're self-employed or a business owner, I would also be looking for what we call Cunningham disclosure or a Sweezy document. These are just cases, names of cases where the courts have dealt with the issue of financial disclosure and laid out rules and clarified rules. So they go by the names of those cases. And what they mean is the financial records of the business. So those are the things I'd be expecting in order to help my client calculate child support. Now, let's say one of the parties, the payor, decides, in this example, we'll say it's the husband. Let's say the husband refuses to provide his income information for the purposes of calculating child support and doesn't have a good reason for why he's not providing it. He's just simply refusing to provide it. In a scenario like that, there are options for the other parent. So normally, my best practice is I first reach out to the other party directly, if they don't have a lawyer, or to their lawyer requesting the information. Hey, can you please provide us the information we need to calculate child support? And usually parties can give anywhere from 20 to 30 days-ish to provide that information. And if after you've requested it, the person hasn't provided it in that time frame, then you are permitted to sort of escalate the situation and take more firm steps in your pursuit of that financial disclosure. That next step in my practice would be to file a request, a formal request, that we want that person's financial information. It's called a notice to disclose in my jurisdiction, which is in Edmonton, Alberta. So we would request that, we would formally request it through the courts by filing a document saying, hey, we're formally asking you for this information. And if, despite filing that document, the other party still doesn't provide the financial disclosure in a reasonable time, the next step that can be taken is putting it onto the court list, putting it in front of a judge to request that the judge order the person to provide it, so that it becomes a court order compelling that other person to provide said financial disclosure. So just to sort of recap, first you directly ask for it in an email. If that doesn't work, you formally request it. You could formally request it via a filed formal request, a notice to disclose, for example. Third option that I implement after that point, if we're not successful, is then putting the matter onto the court list and asking a judge for an order. So you can get a disclosure order. And if that's not being followed, there are consequences that flow. The person not abiding by that order for disclosure may be the subject of a penalty, fine, costs, maybe even contempt. So it's not looked at very well by the courts if somebody is going to not provide their financial disclosure when it's been ordered. No judge likes someone to walk into their courtroom and not be adhering to a court order, because it shows that that person doesn't respect the courts, and the courts don't like that. And they have the power to essentially financially punish that person if they don't abide by the court order. So consequence of not abiding by a disclosure order could be fines, penalties, costs, or a finding of contempt by a judge. Another consequence, or potential consequence, that is, of somebody who's been ordered to provide disclosure and is refusing to provide it, there is an option, it's within the judge's discretion, to do something we call impute income. What that means is, if somebody is not just going to provide their information, if the other party has some information, like let's say they know this person works as a dentist, for example, you could generally find out the ranges online of what dentists earn. And let's say you find out dentists earn, let's say $150,000. And you've got a website like the Alberta, what's it called? Alice? I forget what the acronym is, but there's a website in Alberta that lists all the general ranges for a plethora of careers. So if you can show some sort of proof or indication, that is, of what someone working in that field makes, you could argue to the judge that in the meantime, until we sort out this issue of disclosure, we want you to impute his income at the $150,000, let's say. And if in fact that person doesn't earn $150,000, let's say actually they only earn $75,000, well, then that person's stuck with that imputation at $150,000 until they prove otherwise. So that's a possible option when somebody's refusing to abide by an order for financial disclosure, is that the judge will impute their income and basically say they earn more than they actually do. And that often drives or compels people to start complying, because these court orders, when they get granted, child support order, let's say based on imputed income, then compels that person to pay child support at that imputed income. And if they don't actually earn that much, that can be pretty problematic for the person, because once the other person gets a child support order in place, even if it says that the income was imputed for the payor, that order, that child support order, could be registered with the Maintenance Enforcement Program. And the Maintenance Enforcement Program here in Alberta does literally pretty much one thing and one thing only, and that is to enforce child support orders. They also enforce other orders like spousal support as well, but in this particular example for this video, talk about child support. So they have the mandate to enforce. And so what that means is they'll enforce that amount, let's say imputed amount of $150,000. They'll enforce that imputed amount regardless if it's factually accurate or not. And the only way to undo that for the person that has to pay according to the imputed income is to provide proof, aka the financial disclosure, in order to contrast or in order to counter the imputation of income. So there is a way to undo the imputation of income in the example that I'm giving in this video by a payor who's refusing to provide his or her financial information for the purposes of calculating child support. There are options, as I just mentioned: imputing income, imposing penalties, fines, contempt. The great thing is, though, for the imputation of income part, it can be undone in this example by the person just providing the information. And I never like it when we get stuck on disclosure, financial disclosure. To me, I like to get it done accurately, efficiently, competently, and out of the way so that you can get to the real meat and bones of the situation itself, which would be, in this example, the child support. But for those people that think, I'm just going to keep refusing, making it difficult to ascertain my income by not complying with an order for disclosure, for those people, I have bad news for you. You don't just get away with it. If somebody knows their rights and knows the options that they have, they may take this issue to a judge. And if it is in front of a judge, that judge has the ability to impute your income and set it at whatever they think it should be. And oftentimes, in my experience, when it happens in this way, they are not going to underestimate the imputation of income. They're going to make sure that the income is commensurate with what they think someone in that situation would make. And where does the information come from for the judge to make that determination? From the other party. So if the other party says, yeah, he is a dentist, or he works in the oil field, or she works as a teacher, and it's relatively easy to find out ranges for what people make, that's all they have to come to court with for. So if you want somebody to determine your child support based on an imputation of income, I would definitely suggest you think otherwise. I don't think it's a good idea. I certainly wouldn't advise my clients to do it. I like to get the financial disclosure element out of the way in a comprehensive way as soon as possible. Because if you don't, you can get stuck in this loop of financial disclosure not being provided and parties not being able to move forward substantively, except for when judges are allowed to impute income. That throws a wrench in that party that thinks they can just kind of get away with continuing to not comply and hide their income or keep it a secret. Hopefully this video was helpful for anyone out there. Stay tuned for more. And if you did enjoy this video, feel free, show me some love online. We accept Google reviews. So yeah, thank you so much and tune in. I'll definitely be back with another legal topic. Take care.